Hello and welcome to another episode of the Forge of Freedom podcast. I'm your host, Alex Ooley, and this is episode 124 of the Forge of Freedom. Today I've got a letter that I want to share with you. It's actually a letter from the Attorney General from the state of West Virginia, which was co-signed by a number of other attorneys general from a number of other states. And I'm going to put the letter up here on the screen here momentarily, but it's signed by the attorneys general from, like I said, West Virginia, Alabama, Arkansas, Georgia, Idaho, Iowa, Kansas, Louisiana, Mississippi, Missouri, Montana, North Dakota, Ohio, Oklahoma, South Carolina, South Dakota, Texas, Utah, and Wyoming. And this letter is expressing the opposition by these attorneys general to the Biden administration's announcement of the National Extreme Risk Protection Order Resource Center, which, of course, I talked about along with Mike in episode 118. I'll link to that in the show notes if you want to go back and listen to that. But it was announced by Kamala Harris at Parkland High School in Florida on the anniversary of the massacre that occurred there a number of years ago. And of course, as you all know, we think that red flag laws, as we've said on this show many times, are a terrible idea. But nevertheless, I thought that this letter was worth sharing because I think it makes some good points. And the letter is to Merrick Garland, which is, of course, the Attorney General of the United States. And this letter was sent on April 11th. And the letter says, recently, the Biden administration launched the National Extreme Risk Protection Order Resource Center, a program that pushes for the more aggressive use of so-called red flag gun laws. Working under your department's umbrella, the center aids officials in stripping Second Amendment rights using anti-gun laws in certain localities that allow for the seizure of firearms via civil proceedings. The idea that federal officials would purport to instruct state and local officials on how to implement state and local laws is strange enough, especially when the aim is to undermine a federal constitutional right. But this center is a misguided venture for many reasons. The department must rethink its approach. And I like this point about the feds trying to co-opt the state and local officials to do their bidding, to basically act in opposition to the federal constitution and in many cases the state constitutions of these various states, because the federal government doesn't have the resources itself to implement a national red flag scheme. But the letter goes on. It says, little reliable evidence suggests that red flag laws work. A comprehensive study by the Rand Corporation found no qualifying studies that show a conclusive decrease in incidents like violent crimes, suicide, and other related events. A similar survey from the Duke Center for Firearms Law found no impact on total homicide or total suicide. Likewise, another study examining the use of these laws in 2 states concluded that they had no significant effect on deaths or injuries from mass public shootings. And still another study focusing on a red flag law in one California county did not find evidence for a county-level reduction in firearm assault or firearm self-harm following implementation of the law. Even gun control advocates admit that red flag laws do not significantly predict lower suicide and homicide rates. The available data, then, suggests these laws will likely not save lives. Indeed, these laws might risk more lives by forcing confrontations between law-abiding citizens and law enforcement officers. All right, I'm going to break there for just a moment, and I'm going to share this letter on the screen. But you'll notice here what I've put up on the screen, excuse me, they've footnoted a lot of their assertions here in this letter. In the Rand Corporation and the Duke Center for Firearms Law, those are not exactly conservative or libertarian organizations by any stretch. But then, and of course, they find no support for the red flag laws either in terms of their effect. And of course, that's completely disregarding the abdication of due process in the Constitution. They're saying just looking at the practical effect, there's no conclusive evidence that these decrease violent crime, suicide, or other related events. Even if they were constitutional, there's no evidence that they're effective. The other thing, too, is if you click on the citation here to the study by John Lott and Carl Moody, it's a paper, and they've included the link here in footnote 4. If you follow that link, it takes you to the SSRN website, and the article is called "Do Red Flag Laws Save Lives?" And you'll see here, you can see the whole paper, but they've got the abstract, and it says that in the second paragraph of the abstract, 2 states have considerable experience with ERPOs, Extreme Risk Protective Orders: Connecticut since 1999 and Indiana since 2005. Indiana, by the way, is great on firearms, with the exception of our red flag law. It's a significant stain on Indiana's reputation for being a gun-friendly state, and we are in lots of ways. But nevertheless, this study by John Lott and Carl Moody looked at Connecticut and Indiana and the impact that these red flag laws had in these states. And he said, we use synthetic controls and difference in differences methods to evaluate these laws. The experience in both Connecticut and Indiana is that red flag laws have had no significant effect on either homicide or suicide. We also find that extreme risk protection order laws have had no significant effect on deaths or injuries from mass public shootings. So here we have these laws, red flag laws, that take away, on mere allegations, somebody's firearm, and then only later provides due process, or process at all. Due process would be process up front, okay, before you're deprived of life, liberty, property. That's what the Constitution says. That's what the Constitution mandates. But here we have the President and the Department of Justice and various politicians nationwide who are promoting, who are pushing these red flag laws in an effort to make it easier to take away firearms. And again, this is something that's just obscene, really. They only focus on the firearm. And every state has a mental health commitment process which focuses on not just the firearm. It actually focuses on the person. These processes have due process built in. They have right to counsel. They have all sorts of protections built into the process, and it's not this monomaniacal focus on the firearm with a process that's ripe for abuse. And as this article says, or this letter rather, I'll come back to this letter. Indeed, these laws might risk more lives by forcing confrontations between law-abiding citizens and law enforcement officers. I think this perspective is lost not only in the red flag context, but in lots of other contexts as well. For instance, one thing I talk about a lot is the war on drugs. How often does policing for drugs bring police into a dangerous situation that would otherwise have been completely peaceful? People using drugs for their own consumption. Yeah, it's a terrible thing. I don't condone the use of drugs. I think it's a terrible decision. It's irresponsible, but it's not a crime insofar as it's not hurting somebody else, like a theft or a robbery or an assault. Okay. And so it puts these officers in dangerous situations that they should not be in. And these red flag laws are the same sort of thing. And in some ways, these red flag laws, like drug crimes, are pre-crime sort of laws. That is, these people haven't done anything wrong per se, but we've enforced these laws because we want to try to prevent the potentiality of a real crime occurring. That is, in the drug context, people who use drugs or sell drugs are more likely to commit other crimes. So if we enforce the drug crime, maybe we'll catch them before they commit something that's actually harmful. And that's the same thing with these red flag laws, is that if somebody makes an allegation that they're dangerous and we take away their guns, even if they're not dangerous, at least we might save one life. Okay. And that's just this creepy sort of dystopian pre-crime that, I mean, until the last few decades, you'd only heard about in sci-fi novels. Okay. But the letter goes on. It says, on the other hand, these laws do create serious and undeniable harms. Most obviously, they empower government authorities to suspend fundamental rights under the Second Amendment with no genuine due process, while also stigmatizing persons with mental health issues along the way. Although the specifics vary, no red flag law enacted thus far has fully protected due process rights of the respondent, and some laws foster atrocious violations. Observers have noted how these orders can be issued against persons who show no genuine threat, can be imposed for extended periods of time, and can be sought for reasons as minimal as overblown political rhetoric on social media. And it's not just the Second Amendment that's at risk. How can officers enter a home and seize a gun without a warrant in a way that's consistent with the Fourth Amendment? How can ex parte proceedings unconnected to any criminal wrongdoing or criminal investigation be good enough under the Fifth and 14th Amendments when they lead to firearms seizures? Both questions have the same answer. They can't. By depriving individuals of their property and rights without having been formally charged, arraigned, or convicted of a crime, red flag laws violate these constitutional rights. No wonder that Congress has already called out your department for funding state-level red flag programs that fail to meet basic statutory and constitutional requirements. Given these substantial concerns, one might have at least expected the federal government to step aside and let the states chart their own course. But your department believes that one level of government is not enough, and Vice President Harris has challenged every state to pass a red flag law, insisting that the 29 states that haven't adopted them, let alone the states that have banned them, are in the wrong. She further bemoaned how only 6 states have taken up the offer from the federal government to help them with the training and the implementation of these red flag laws. The new resource center is evidently an effort to strong-arm more states into accepting help. Trouble is, nothing in the Bipartisan Safer Communities Act, which you cite as the impetus for this center, authorizes your department to create it in the first place. Funding is supposed to go to states and units of local government, not to the department's own coffers. And when one looks closer, it's no surprise that so many states want so little to do with this new center and similar support efforts. The center is a project of the John Hopkins Center for Gun Violence Solutions, an ostensibly nonpartisan institution that, in fact, strategically advocates for strict gun control measures driven by equity and left-oriented policy priorities. And we pointed this out in episode 118. We talked about this John Hopkins Center for Gun Violence Solutions, which the Department of Justice partnered with to create this center, but it's funded by Bloomberg. if you go to their website, it says clearly, the Bloomberg School of Public Health, I think is what it says. And Michael Bloomberg, for those who don't know, has been a staunch advocate for gun control for many, many years. It is, the letter goes on, it is a successor to an organization, the Educational Fund to Stop Gun Violence, that originally sought to ban all handguns and so-called assault weapons outright. It is now allied with several progressive state anti-gun groups. The Hopkins Center is co-directed by an individual who describes the landmark decision of Heller versus District of Columbia as one enshrining an individual right to insurrection, a right that he believes is damaging to democratic values. And the center has called New York State Rifle and Pistol Association versus Bruin an arbitrary limitation that has facilitated subjective analyses and unconscionable questions. Plainly, these are not harmless policy wonks who offer a little well-meaning assistance to states on the ground. Rather, your department has partnered up with anti-gun ideologues who perceive essential Second Amendment protections to be inconsistent with American values. In short, your new resource center is flawed in multiple basic ways. We urge you to put an immediate stop to this program. States don't need help of this sort from the federal government. We know exactly how to protect our citizens while appropriately respecting Second Amendment rights. And that's the end of the letter there. Like I said, I'll link to all this in the show notes, of course, like I always do. But it's funny, I like how they put help at the end here in quotes. States don't need help, and it makes me think of the common phrase that one of the most concerning phrases in the English language is that I'm from the government and I'm here to help. And that's especially true when you're talking about the federal government and the current Department of Justice. And that's the attorneys general here are exactly correct that the department, the Biden administration and the Department of Justice are weaponizing the dollars that were set aside by the Bipartisan Safer Communities Act for their own ideological preferences. And that is an ideological preference to eliminate freedom and the Second Amendment and the right to keep and bear arms. And so I applaud these attorneys general. I don't know how much difference it will make, but I think that their letter here is pretty succinct and gets it mostly correct. I don't have much of a problem with anything they've said here. I really like this letter, and I like that they link to a lot of their sources, and they reference some great sources here. I mean, Dave Koppel. I mentioned John Lott earlier. They reference him again, along with Thomas Massey. And then they also reference some more neutral, like I said, the Rand Corporation and the Duke Firearms Law Center, or Center for Firearms Law. So go back and read this letter. I think that if you read this once or twice more, you'll be well equipped to talk about this topic, the topic of red flag laws, when you hear about it in general conversation and when you hear about it on the news. The other thing I want to think about, play here, people have a short memory, and I think Trump is probably hoping that most people forgot this, but a lot of people in the gun community have not forgotten what he had to say about red flag laws a few years ago. And I'm going to play it here on the screen. If I can get the right view here. Here we go.
They have less power over me. What do I need? It takes so long to go to court, to get the due process procedures. I like taking the guns early, like in this crazy man's case that just took place in Florida. He had a lot of firearms. They saw everything. To go to court would have taken a long time. So you could do exactly what you're saying, but take the guns first, go through due process second.
Take the guns first, go through due process second. That's what former President Donald Trump had to say about due process and the right to keep and bear arms. Take the guns, take the property first before due process is provided, which is exactly the opposite of what the Bill of Rights says in the 5th and the 14th Amendment. It says twice, you can't be deprived of life, liberty, property without due process of law. And the president gets it exactly backward. Former President Donald Trump gets it backward. Current President Joe Biden doesn't even care if he gets it backward. And the Department of Justice is using your money, your tax dollars, to try to take your rights away without due process. So this is a subject that I think is really important to the right to keep and bear arms and to freedom. Because this is just another tactic, another method, another angle to take away our rights. Of course, they're also trying to get universal registration, which we've talked about previously, but is death by 1,000 cuts, and ultimately confiscation of all firearms is the goal. All right, so I hope you enjoyed that. One last thing I want to put on your radar: the Supreme Court is going to conference with respect to 2 cases involving assault weapons bans, one in Maryland and one in Illinois. The Maryland case is Bianchi v. Brown, and the Illinois case is Harrell v. Raoul. They're going to conference about those 2 cases on May 16th, and hopefully the Supreme Court agrees to grant the petition for certiorari, the petition to review those cases in the fall. So, I mean, these states, in the 7th Circuit in particular, I mean, they've just completely ignored and tried to disregard the common use test that it was expounded in the Heller case and affirmed in the Brewing case, and basically done whatever, jumped over backwards. They've gone through many mental gymnastics to uphold these assault weapons bans. And so these cases are ripe to be heard by the Supreme Court, and I hope the Supreme Court will hear at least one of them. So I wanted to put that on your radar. We'll certainly be talking about that again sometime in the near future after the Supreme Court has conferenced about those cases. All right, everybody, I hope you enjoyed the episode. If you did, don't forget to like and subscribe to help us spread the message of freedom. As always, you can find us on YouTube, Facebook, Rumble, and all of the most popular podcast streaming platforms. You can also find me on X at Forge of Freedom and at forgeoffreedom.com. All right, everybody, thanks for tuning in. And until next time, remember, you are the Forge of Freedom.
Thanks for listening to this episode of Forge of Freedom. Be sure to subscribe wherever you heard this podcast so you never miss a future episode. For more information or to connect with Alex, you can go to forgeoffreedom.com or follow him on Twitter at Forge of Freedom. Until next time, remember, you are the Forge of Freedom.